Hello friends, in this video I am going to discuss what is difference between common law system and civil law system. Throughout the history to present day, the two principal legal systems have been practiced in the world, namely common law system and civil law system. The common law systems evolved over the period of time largely through customs and practices are practiced largely in the UK and its former colonies, the United States, Canada, Australia, India, etc. On the other hand, the civil law system, which is codified laws and rules, are largely practiced in continental Europe, South America, Japan, China, etc. The evolution of common law system most likely began a millennium ago in England. On the other hand, the roots of civil law system are linked to ancient Roman law. So, in this video, I will discuss the concepts and major distinct features of common law system and civil law system. Let's start with the first one, that is the legal meaning. Common law system, it is uncodified law. Civil law system, it is codified law. Next, history and evolution. Common law system mainly evolved in England and in its colonies, whereas civil law system evolved in continental Europe. Next, sources. The sources of common law system are judicial precedent, custom, convention, statutes, and subsidiary legislation, and international law, whereas the sources of civil law system are constitution, statutes and subsidiary legislation, customs, and international law. Next, constitution, common law system, as such not essentially required, but the most of the countries practicing common law system as such not essentially required, but the most of the countries practicing common law system have the constitutions. Civil law system. In civil law system, constitution is essentially required. Next, precedent. Common law system, precedents are commonly used to decide the cases. In civil law system, precedents are used to determine typically administrative or constitutional court matters. Now, let's discuss some differences in terms of judicial proceedings. Types of trial. In common law system, the types of trial are accusatorial and confrontational, whereas in civil law system, the types of trial are inquisitorial and collaborative. Next, functions of lawyers. In common law system, the functions of lawyers are based on debate and oppose, whereas in civil law system, the roles and functions of lawyers are to give advice and to inform. Next, during the trial, roles of judges. In common law system, judges are considered as referee or as umpire, but in civil law system, judges are considered as director or examiner. Next, selection of judges of higher courts. In common law system, political appointment from practicing lawyers or judges of lower courts, whereas judges of lower courts are appointed through competitive examinations largely, whereas in civil law system, the appointments of judges are merit based from judicial specialists. Next, that is geographic regions, countries. Common law system largely practiced in UK, USA, Australia, Canada, India, etc. Whereas civil law system largely practiced in continental Europe, including Germany, Spain, South America except Guyana, Japan, China, etc. This is all about the major differences between common law system and civil law system.